If you are outside the U.S. and the 310-year unlawful presence bar applies to you, you will need a waiver to immigrate to the U.S. If you do not get the waiver, you will normally need to wait outside the U.S. for 3 or 10 years to get an immigrant or K visa. Hi, my name is Dyan Williams and I'm an immigration attorney. In this video, I'll talk about the Immigrant I-601 or I-601A Waiver for Unlawful Presence. There are two key things you need to know about the Immigrant I-601 or I-601A Waiver for Unlawful Presence. Number one, you need the waiver only if you're immigrating through the U.S. consulate. The 310-year unlawful presence bar is triggered only if you leave the U.S. after accruing a certain amount of unlawful presence. If you accrued unlawful presence of more than 180 days to less than 1 year, the bar to re-entry is 3 years. If your unlawful presence lasted for 1 year or more, the bar to re-entry is 10 years. If you're already in the U.S. and can somehow get your green card through adjustment of status, this is the better path to take. That way, you avoid triggering the 310-year bar. An example is a spouse of a U.S. citizen who came to the U.S. lawfully, say with a B2 visitor visa, but then overstayed. That person can normally apply for adjustment of status based on marriage to a U.S. citizen despite the overstay. If they adjust status and do not leave the U.S. for consular processing, then the bar is not triggered. The second thing you need to know about the Immigrant I-601 or I-601A waiver is that you must have a qualifying relative who will suffer extreme hardship if you are not admitted to the U.S. A qualifying relative is a U.S. citizen or permanent resident spouse or parent. It does not include U.S. citizen or permanent resident children. The hardship also needs to be extreme, that is, beyond the normal hardship that comes with a family separation or relocation of the qualifying relative to be with you. The hardships can include financial problems, mental or emotional distress, physical or health conditions, as well as loss of opportunities. There are two key things you must do to get an immigrant waiver for unlawful presence. Number one, you must determine whether to file a Form I-601 waiver application overseas or Form I-601A provisional waiver in the United States. The I-601A is filed only if you're still in the United States. It is only for certain types of applicants, such as a spouse of a U.S. citizen I-130 petitioner. The I-601A can also only be used to overcome unlawful presence. If you have other grounds of inadmissibility, such as criminal convictions or fraud or willful misrepresentation to gain immigration benefits, you cannot file an I-601A. Instead, you do need to attend your visa interview abroad and then file an I-601 waiver application. The second thing you must do to get an immigrant waiver for unlawful presence is to present documents and information showing that your qualifying relative will suffer extreme hardships if you are not admitted to the U.S. An affidavit from you, the visa applicant, and the qualifying relative describing the hardships in detail will be very helpful. You also need to present objective documents such as medical reports showing health conditions, a psychological evaluation showing mental distress, household bills or federal tax returns showing that your qualifying relative depends on you financially. A legal brief from an experienced attorney connecting the dots and explaining how you qualify for the waiver and why you deserve it as a matter of discretion is also critical. If the 310-year bar applies to you, you will need to file for an Immigrant I-601 or I-601A waiver to immigrate to the U.S. The waiver is hard to get. If you're already in the U.S. and can somehow file for a green card through adjustment of status, this is a better path to take. That way, you avoid triggering the 310-year bar because you departed the U.S. for consular processing. If you do need to immigrate through the U.S. consulate, you need to determine whether to file an I-601 waiver application while you're overseas after you attend the visa interview, or file an I-601A waiver application while you're still in the U.S. before you attend your visa interview. For more information on the Immigrant I-601 or I-601A waiver for unlawful presence, hop on over to my website and read my articles on my immigration blog or watch my other videos. If you need specific advice or guidance on the waiver process, call me or contact me through my website at dyanwilliamslaw.com.